If you own your home and you're over 60, there are 5 documents, or the absence of them, that could decide whether your family keeps everything you've worked for, or loses a huge chunk of it to legal costs, care fees, and tax bills that could have been avoided completely. One of these became far more urgent this year, and another has a window that's closing faster than most people realize. Welcome back to Pension and Benefits Guide, the channel where we explain confusing DWP and government rules in plain, simple English. Today we're covering all 5 documents, what happens when they're missing, and the mistakes that catch most people out. Let's start with the one that protects you while you're still alive, the lasting power of attorney, or LPA. It lets someone you trust manage your affairs if you lose mental capacity. There are 2 types, property and financial affairs, and health and welfare. Without a registered LPA, your family cannot access your bank accounts or make care decisions for you, no matter how obvious your wishes are. They'd have to apply to the Court of Protection, which can take 6 to 12 months and cost £3,000 to £5,000. During that time, your finances are frozen. Here's the detail that catches people out. The Office of the Public Guardian takes 8 to 20 weeks to register an LPA, costing £82 each, or £164 for both. But if you lose capacity before it's registered, it cannot be registered at all. A signed but unregistered LPA has no legal power. Starting the process isn't the same as being protected, finishing it is. If you don't have both LPAs registered, start this week, not this year. The second document is your will, something around 60% of UK adults don't have. Without one, intestacy rules decide who inherits, regardless of your actual wishes. Unmarried partners get nothing under these rules, no matter how many years together. And blended families can end up with outcomes nobody would have chosen. Here's the mistake most people make. Getting married automatically cancels any earlier will under English and Welsh law. So if you wrote a will before your current marriage and never updated it, that will is void. If you've remarried since your last will, check right now whether it's still valid. Chances are it isn't. Quick pause. If you're finding this useful, hit like, subscribe, and tell me in the comments which of these 5 you're checking first. The third issue is costing UK families the most money right now, care fees. 40 to 70,000 homes in England are sold every year to fund residential care. The self-funding threshold is £23,250, and care costs £1,200 to £1,500 a week. At that rate, a home can be gone within 3 to 4 years. The detail that trips people up is how the property is owned. As joint tenants, the whole property counts in the care fee means test when the survivor needs care. As tenants in common, you can leave your share through your will into a discretionary trust, which, structured properly, may not be automatically counted. Done correctly, this can protect a meaningful part of the property's value. Speak to a solicitor about this if it applies to you. Now here's where the real impact becomes clear. The 4th document most people assume is covered by their will. It isn't. Pension pots pass through an expression of wish form held by your provider, not your will. An outdated form naming an ex-spouse or a deceased relative means your pension could still go to the wrong person. And this matters more than ever this year. The Finance Act 2026 confirmed that from the 6th of April 2027, unspent pension pots will be included in your estate for inheritance tax for the first time. Right now they pass tax-free. From April 2027, they'll attract the standard 40% charge above your nil rate bands. Contact every pension provider you have and update your expression of wish form now. None of these 5 documents are expensive to fix, usually a few £100s. Not having them can cost tens of thousands, sometimes the family home itself. So here's the full picture. Get your LPAs registered while you have full capacity. Check if your will was made before your current marriage. If you're joint tenants, talk to a solicitor about a discretionary trust. And update your pension's expression of wish form before April 2027. So tell me in the comments, which of these 5 are you missing? And if this helped, share it with anyone over 60 who owns their home. I'll see you in the next video.